Before I came to Michigan, I was a law clerk to a federal judge on the D.C. Circuit Court of Appeals. After that, I clerked on the Supreme Court of the United States. I also served some time at the U.S. Department of Justice, where I was a Deputy Assistant Attorney General in the Office of Legal Counsel. I've used many of my experiences from practice in my classroom. I teach a seminar on presidential power, and the sorts of issues that I was exposed to in the Justice Department are central to the development of my students' appreciation of the work of an administration lawyer. One of the things I really try to get across to my students, especially in that seminar, is that the law on paper and the law in practice are not actually different things, but they're different lived experiences. So it's one thing to read a case and say, well, on the authority of this case, I think the president can clearly take this particular action. It's a different thing when the rubber meets the road and you're actually going to authorize the president to take this sort of action based on an authority that may be good law, but hasn't actually been used very much since 1929. Probably the piece that takes the biggest chunk of my time is the clerkship advising. I advise students to help them figure out what kind of clerkship would be best for them, and also to make connections between students and judges. So I spend a lot of time on the phone with judges talking to them about which Michigan students I think are a particularly good fit for their chambers. Things that judges are looking for are very idiosyncratic. There are 250-some members of the federal appellate judiciary and 1,000 district and magistrate judges. They're all looking for different things, and none of the things they're looking for are published in a book. So having that institutional memory, having one person who knows what judges are looking for and who has the set of relationships is really something that I think Michigan has done very well.